Company Limited and DG Satria.
Yes, Mr. Todd.
My Lords, my Lady, this appeal, as you will know, is concerned with the effectiveness of a sale and transfer of the whole of the issued share capital of a company known as Barley Energy Limited, I'll call it BEL if I may, by the respondent, East Asia Company Limited, and I'll call that EACL, for whom my friend Mr. Howard appears, to the appellate PT Satria, I shan't pronounce its full name, for whom I appear. PT Satria's case it may be put, I think, simply in this way. We say that the sale of the whole of the issued share capital in Barley Energy was effected by, firstly, heads of agreement dated the 27th of February 2015. The executed version is at bundle 5, page 1622 of the record, which heads of agreement Mr. Jones had ostensible authority to conclude on behalf of EACL, and a transfer dated the 1st of March 2015. The transfer is at bundle 5, page 1632. We say alternatively, or further or alternatively, the sale was effected by the ratification of that sale and transfer at a board meeting of EACL, held on the 1st of March 2015.
I'm going to rise simply because what my learned friend has just said about the ratification, I do not believe is within the grounds of appeal. I do not believe that they have appealed the finding that the board meeting did not ratify. Seen in the skeleton argument, I don't think in the case ratification is suggested as an issue. It only came to my attention that this may be being raised last night when an authority on ratification was sent through.
Yes, Mr. Todd.
My Lord, the position is this, that firstly, can I just, I will go to the grounds of appeal. Can I just go firstly to our, just so that you are aware, can I go firstly to our written case, just so that you see this clearly in context.
Yep.
Our written case commences bundle 6 at
1847.
Thank you. And then if I could invite your attention, please, to page 1849, Court of Appeal findings challenged by PT Satria. Paragraph numbered 8, the principal judgment in the Court of Appeal was given by Justice of Appeal Clark, and he held that the HOA was entered into by Mr. Jones on behalf of EACL without any actual or sensible authority. And secondly,
yes,
the HOA was not validly ratified at the 1st of March 2015. Now, my Lords, my Lords and my Lady, the grounds of appeal, and I'm grateful to my friend for drawing it to our attention at this late stage. In the grounds of appeal, may I invite your attention to grounds of page bundle 6, page 1761. And what we say, perhaps I can go to 1759. 1759, I'm sorry to move you around. Same bundle. The issues raised by this appeal are as follows. You see that, issues in the appeal to the Privy Council, towards the bottom of the page. Whether the HOA was entered into by Jones, that should be Mr. Jones, of course, on the part of the ACL with a sensible authority. That's ground 1. 2, whether PT Satria was put on inquiry as to A, Mr. Jones' lack of authority, or B, the failure of Mr. Jones to disclose his interest in the HOA, and 3, whether the HOA, that's heads of agreement, was avoidable by EACL and or avoided. And then, may I then invite your attention to page 1761, where we see ground 2. Findings that PT Satria was put on inquiry as to A, Mr Jono's lack of actual authority, and B, Mr Jono's failure to declare an interest in the HOA. We say where the court erred, and then we say halfway down the page, or just after halfway down the page, put on inquiry as to Mr Jono's failure to declare an interest in the heads of agreement. The court ought to have concluded that by reason of the rule in Turquin's case, PT Satria was entitled to assume that all necessary internal requirements disclosed in consents within EACL in relation to the HOA had been satisfied, made and given. B, PT Satria was entitled to assume that in entering into the HOA on behalf of EACL, Jones was properly and duly performing his duties and exercising his powers on behalf of EACL. C, PT Satria was not bound to inquire whether the internal requirements of EACL, including any obligation on Mr Jones to declare an interest in the HOA, had been satisfied. D, PT Satria was not put on inquiry as to whether Mr Jones had declared an interest in the HOA, so as to preclude PT Satria relying on the ostensible authority of Mr Jones to execute the HOA, and E, a failure by Mr Jones to declare an interest in the HOA in accordance with the bylaws was precisely the type of internal management issue covered by the rule in Turquin's case, with which PT Satria was not concerned by reason of that rule. And so on. My Lords and my Lady, we there set out extensively the way we put the argument. And so we say it is clearly within the grounds of appeal on this appeal.
The declaration of interest point is simply not an issue unless the board resolution is an issue.
Absolutely, absolutely. My lady has it precisely. I will come on to how the Court of Appeal dealt with it, and the Court of Appeal dealt with this point about the board, the board resolution of the 1st of March by saying it failed on really 3 grounds. I'm going to come on to those, but one of those is declaration of interest. The other was apparently an alleged insubstantial amount of information being before the board, and I think the third point was on not having a proper instrument of transfer. They all relate to the board meeting on the 1st of March. And then if one goes over to ground 3 at page 1765, we say findings as to the right of EACL to avoid the heads of agreement. The court erred in finding the heads of agreement was avoidable by EACL in that, in order for a contract to be voidable by a company against a third party, such as the avoidance by EACL of the heads of agreement against PT Satria, it is necessary for the third party to have notice of the irregularity or to have been put on inquiry about it, as the court rightly found. EACL has not contended that PT Satria had notice of an irregularity, namely a failure by Mr Jones and Harter to declare an interest in EACL in the heads of agreement. For the reasons set out under ground 2 above, PT Satria was not put on inquiry as to any such irregularity.
Yeah. And Mr. Todd, if one goes to 1832 in the Statement of Facts and Issues.
My Lord, yes.
I'm just wondering, paragraph 9 there, the last few lines refer to a question whether the resolution passed on the 1st of March was ineffective.
Yes.
And then paragraph 10 over the page, alternatively, whether the board could have ratified the HOA in the absence of full disclosure.
Absolutely.
So do you say those identify the point you're wanting to argue?
Indeed, my Lord, they do. And also one goes on, of course, also in relation to issue 2A, we say at 1833, whether PT Satria was put on inquiry, and then whether if the test for when a third party is prevented from relying upon a sensible authority agent is whether the third party was put on inquiry as to his authority. We say 2B, and whether PT was put on inquiry as to Mr Jones' lack of authority by means of the matters set out, and then whether PT Satria was put on inquiry as to Mr Jones' failure to declare an interest in the HOA. And that's those sub-issues under 2B.
Yeah.
So, my Lord, with the greatest respect to my learned friends, for whom I'm very grateful to draw on this to everybody's attention, it's taken 10 minutes to deal with. With the greatest respect, this is well within the grounds of appeal.
Yes. We'll allow Mr. Howard an opportunity to respond.
Lord, if you go to the grounds of appeal, you will actually, firstly, you will not see anywhere in the grounds of appeal the suggestion that the Court of Appeal should have found that the board did ratify the transaction. And Mr. Todd is unable to point to anything that says that. Now, when you look at the issues that he referred to you to at 1759, again, you will see an absence of anything relating to ratification. So the issues he referred you to are what the first one was ostensible authority. The putting on inquiry is all relating to the issue of ostensible authority. It is not relating to the board meeting. The board meeting, that wasn't part of the decision of the Court of Appeal that they were put on inquiry about what happened at the board meeting. They didn't see the minutes of the board meeting. The issue in the Court of Appeal was simply whether the board meeting was a quorate board meeting in the absence of proper disclosure. It had nothing to do with the knowledge of the other side. So this isn't a case where somebody was saying, I saw the board meeting minute and I was relying on that minute in some relevant respect, and so that the rule in Turkwind might be relevant to that. Equally, 3, whether
with the agreed statement of facts and issues, is normally what we look to see what the issues are.
Yeah.
This is an agreed statement of facts and issues.
Yeah, my Lord.
Are you saying that this point is not covered?
Can I come to that?
Well, no. I mean, we normally start with agreed facts and issues.
Yeah, my Lord.
May or may not be the same as the grounds of appeal.
Yeah.
But at least by the time we get here, we expect the parties to have
my Lord,
worked out between them what the issues are.
My Lord, I'll turn to the statement of facts and issues. If you go to the way in which sorry, I'm looking in the wrong place. At the issues. If you look at what issue 1 is, on page 1831, it's whether Mr. Jones and Mr. Hatter had ostensible authority to make the HOA on behalf of EACL. So that's the issue. What then follows are sub-issues relating to that issue.
Well, you're saying that, Ms. Howard, but it rather looks as though 9 and especially 10
Yes.
are raising the question whether, effectively, even if there was no ostensible authority in relation to the HOA, whether nevertheless it was effectively...
Can we just see what is actually said in 9? Got to remember, the decision of the Court of Appeal was that there was a conflict of interest and something that required to be disclosed by reason of the financial interest that Mr. Jones and Mr. Hatter had in the transaction.
Yeah.
Now, in the grounds of appeal, that point, i.e. that there was a conflict of interest and this was something that required to be disclosed, was not appealed. In this statement of facts, that is also not appealed, because if you look at paragraph 9, the issue that's put there as a sub-issue is whether the effect of the conflicts of interest was that they were precluded from voting as directors unless they first declared their interests. So the first thing to note is this proceeds on the premise that there was a conflict of interest. The issue that's introduced here, which in my submission goes beyond what was in the grounds of appeal, but so be it, was simply as to the legal effect of the conflicts of interest, whether that precluded them from voting. And you will have seen in the in the written case, there's nothing about the legal effect. The written case proceeds by making an argument that there wasn't a conflict of interest.
No, sorry, the last 4 lines are about the consequence of the meeting if they'd failed to make a declaration of interest. And the consequence which is in issue is whether that therefore made the resolution approving the sale ineffective. That's going to be the issue, if this point is allowed.
But, my lady, there are 2 separate points that arise, though. I'm sorry if I didn't make that clear. The first is, was there in fact a conflict of interest? I.e., was the Court of Appeal right to find there was a conflict of interest as a result of these transactions? And you will not find anywhere in the grounds of appeal or in the statement of facts and issues where it said that that is an issue as to whether in fact there was a conflict. What this was seeking to introduce into the grounds of appeal, or into the statement of facts, was what the legal effect was. You can see whether the effect of the conflicts of interest was that they were precluded from voting. It's not, was there a conflict of interest? That would have been a prior issue. Now, it's entirely right to say the way that is drafted is raising a legal question as to what is the effect of the conflict of interest. But as I understand it, no one in fact is disputing that if there is a conflict of interest, that it has the legal effect that the Court of Appeal found, and that there's nothing in my friend's written case about that.
I don't think that is necessarily so. It's not disputed that there was an interest. It'd be difficult to see how it could have been.
Yes.
But the question of whether that was a conflict of interest, I thought, was an issue. And putting that on one side and parking that issue, there is still an issue as to the effect of the board meeting of the 1st of March.
My lady, I agree.
The mere fact it's in quorate doesn't mean to say that third parties can say there was no resolution.
Yeah. And if I could add to that, I mean, obviously a chance to answer in a moment, but the reference in paragraph 9 is to the Court of Appeal judgment at paragraph 97.
Yes.
Where what's said is that Jones and Hatter were disqualified from voting at the board meeting, and it was in quorate. There was therefore no valid approval of the HOA or the transfer, and the purported ratification was without legal effect. It rather looks as though paragraph 9 in the issues is meant to place that in question.
Well, paragraph 9 on its face appears to be doing is putting in dispute the legal consequence of the conflict of interest, as opposed to the question, in my submission, the prior question is, was there a conflict of interest? And in my submission, that isn't something which has been challenged, either in the grounds of appeal, it certainly wasn't in the grounds, and nor in my submission in the statement of facts and issues. So that if the statement of facts and issues is to be treated, as it were, as expanding the scope, and of course it's an agreed document, all it expanded its scope was as to the legal effect of there having been a conflict. And in my learned friends, the written case, you won't find any argument that the legal effect of the conflict of interest was not to render this meeting in quorate. No. And paragraph 9, which is whether the board could have ratified in the absence of full disclosure of all the material circumstances relating to the HOA, which is then cross-referring to paragraph 98 of the Justice Appeal Clerk's judgment, is where he said even if they had been entitled to vote, there couldn't have been a valid ratification without full disclosure. So it's essentially the same point, and this is raising that legal question.
That's explicatory of 97. The purported ratification was without legal effect, and 98 explains in more detail why.
Well, I think it's a further point. It's saying
yes.
Even if they were entitled to vote, it wouldn't be valid anyway without having made full disclosure. I mean, at the end of the day, it all comes down to the same thing, whether it's a separate point. Anyway,
so paragraph 9 in the in the issues is directed towards paragraph 97 of
Yes.
the judgment, which, the conclusion reached there is that because they were disqualified from voting, the meeting was inquorate, and therefore the purported ratification was ineffective. And then issue 10, paragraph 10, is concerned with the paragraph 98
Yes.
of the judgment, where the the conclusion is, or reasoning is, that even if they'd been entitled to vote, because there was no full disclosure of material circumstances, there was, for that reason, also no valid ratification.
Yes, but the findings that have previously been made about conflicts of interest are earlier in the judgment, and paragraph 97 and 98 are then looking at the legal consequence. Now, it's fair to say against me that legal consequence argument is introduced in the statement of facts and issues when it wasn't in the grounds, and that may, as it were, preclude me from saying they can't run the point at all. But in my submission, the only point that is properly run when you look at the two documents is just a question as, given the conflicts of interest and the failure to disclose, what is the legal consequence of that?
And you say, something Mr. Todd said earlier on, I've slightly forgotten what it was, excited you to the thought that he was going beyond those issues.
Well, the reason we became aware that they were maybe running a case was last night they sent through an authority on ratification. Ratification, you will have seen in the written case, ratification doesn't feature at all. No reference to authorities, and the points raised at sub-issues 9 and 10 are not addressed in the written case.
But you're not saying they can't raise them now?
Well, it's really a matter for
we got the statement of facts and issues.
Well, in my submission, they come.
A lot of issues.
If there's a lot of issues, ultimately, in my submission, if the court says they should be entitled to run the ratification point, I'm not, as it were, worried about it. In my submission, what the Court of Appeal has found is overwhelmingly right. It's a matter really for the court in its procedure as to whether one can, as it were, put something in the grounds of appeal, which is then not reflected in the statement of case, and say, well, I want to argue this because this reflects what we were arguing before.
It's my point, but I'm becoming slightly confused about what is being meant by the ratification point. I can see that there's, well, it seems to me that there are potentially two aspects to that. One is internal ratification, duly and properly, equivalent, if you like, to actual authority in the board then to issue a particular decision. And I can see that it may be the case that for the reasons you've given, there isn't a challenge, you say live, to that aspect of the conclusion of the Court of Appeal, that there was no such internal valid ratification. Yes. But isn't there a separate question whether, by virtue of Turcon's rule or some other principle of ostensible authority, when PTS is then transacting thereafter with EACL, it may have been entitled to assume that there had been valid ratification, even though there had not.
No, there isn't on the facts of this case, there isn't.
Right, but in terms of the arguments which are open and are being run, is that not, you say that's not an aspect?
Nothing is, the ostensible authority case is entirely a reference to having ostensible authority to enter into the case of agreement. On Friday. Yeah. You can see, I don't really think that's an issue. There's not some subsequent acts that are relied on to create a dealing, as it were, which EACL is bound.
But Mr. Howard, you can't win at that point because of the resolution of the 1st of March. You have to say Satria was not entitled to rely on the resolution of the 1st of March, or not, that there was no ratification, because on the face of it, there was.
That's why the Court of Appeal took that issue first. the structure of the judgment was they considered the 1st of March. And one would have naturally expected, if this was the issue that was being run, that what would have been said is the Court of Appeal was wrong to find there wasn't ratification on the 1st of March, and that would be the central issue. Whereas the issue in the case and the issue before you is whether or not there was ostensible authority to enter into the HOA.
Yeah. Yes, so really what it boils down to is that although the statement of facts and issues identified points relating to ratification in paragraphs 9 and 10, they're not argued in the written argument, in the written case.
Those are not the arguments that are being argued. And indeed, the real argument that is being run in the written case is that there wasn't actually a conflict. That's of interest, so there was nothing to disclose. And the rule in Turquin's case is only coming in, perhaps I just need to explain that, it only comes in this sense that the Court of Appeal, one of their findings was that Satria, PT Satria, was put on inquiry as to whether or not disclosure had been made. And that's not by reference to the board meeting, it's disclosure by reference to when the HOA is made. Mm-hmm. And that's where they're relying on the internal management rule to say that they're entitled to assume it had been. Yeah. Lord, I hope I haven't wasted too.
I take it you're maintaining that you're prejudiced by the point being raised in oral submissions without it having been covered in the written case?
Well, my Lord, I'm not going to say I'm prejudiced in the sense that I can't argue the case, but in my submission, one has to have some sort of clarity as to what is properly within without the appeal.
Yeah.
And we would suggest that the appellant took a decision when they launched the appeal to limit their appeal to the ostensible authority point. Then at some point they appear to have decided, well, we're going to raise this limited point on ratification, but which they haven't pursued in the written case, and the written case is now sought to pursue a different point. In my submission, the court shouldn't allow that.
Okay. Mr. Todd, what do you say about the absence of any argument in your written case on this point?
Yeah, my Lord, I'm grateful that whilst my friend was speaking, I was rudely turning through my case to make sure I had dealt with it. And I invite my lords and my ladies' attention to page 1862 of Bundle 6, where we deal with issue 2. And what we say is this, that the issue is whether PT Satria was put on inquiry. And we know that putting on inquiry, may I preface what I'm going to say in this way? My lords and my lady will have seen that the main judgment given in the Court of Appeal was given by Justice of Appeal Clark. Mm-hmm. And you'll see that he, if I may put it this way, conflated what I would think are really two distinct issues. That is the test for when there is ostensible authority and when that ostensible authority may be undermined, which is the decision which has been dealt with in Akai in the Court of Final Appeal in Hong Kong fairly recently, Lord Newberger giving the judgment of the Court of Final Appeal. And that's one issue he's conflated. The other issue he conflated was this notion of put on inquiry. And put on inquiry to a company lawyer, as will be well familiar to the board, is really usually used in the context of indoor management principle in Turquin. That is, whether or not a board meeting has been regularly proceeded with. Now, but that you see, what the Court of Appeal did, they seem to conflate those two issues and try and run them together. I'll be coming back to, if I have a moment to, come back to the judgment in due course. But if I may pick it up again as 1862 on Bundle 6, issue 2 is there set out. The person dealing with an agent be precluded from relying on the agent's ostensible authority. The person knows or has reason to believe. That's criterion. However, notwithstanding those findings, Justice of Appeal Clerk held that Mr Jones and Mr Harter were not authorised by EACL. And then we deal with no actual authority, undeclared interest, because this is what the judge was relying on also at 1863, our paragraph numbered 49 and 50. So he was referring there to the undeclared interest. It wasn't just... and then one goes on to see, one sees there on page 1866, we take Turquin full on. Paragraph 58.
49 expresses the essential point.
Absolutely.
Because it was a case where there was a board resolution.
Absolutely. The short answer to this point...
they were entitled to assume it was regular.
Absolutely.
See Turquin. That's your case. Right on.
Absolutely plain as a pikestaff, in our respectful submission. And then we address Turquin at 1866. Paragraphs 58 and following. And then we say in issue 3, Justice of Appeal Clerk held the HOA was avoidable and has been validly avoided by EACL. This stands or falls with the Justice of Appeal Clerk's conclusion that PT Satria is unable to rely upon the ostensible authority of Mr Jones and Harter because it knew or had reason to believe they lacked actual authority or had failed to declare an interest. That can only be at the board meeting of the 1st of March. The declaration of interest can only relate to the 1st of March. It can't relate to the heads of agreement on the 27th, because we're not relying on a board meeting on the 27th of February. If PT Satria is entitled to rely on the sensible authority of Jones and is not precluded from doing so by knowledge of or notice of those matters, and or is entitled to rely on the rule in Turquin's case, the HOA is not avoidable by EACL.
Yeah, but you're, as far as I can see at the moment, what your argument really here is that the alleged failure to disclose the conflict of interest, you say, because it's a matter of internal management and therefore covered by the rule in Turquin's case, has the consequence that the failure to disclose the conflict of interest doesn't undermine the ostensible authority of the two directors.
Absolutely.
Mm-hmm. Or the board resolution.
Or the board resolution.
I'm looking for the latter.
Yeah, absolutely, or either of them. The thing is, then we are entitled. We are entitled to rely on Turquin's case. That
for example, 1867. You're relying on your discussion issue 2, where it takes us in the paragraph given letter D there, is that the alleged non-compliance is in respect of matters of internal management. Accordingly, PTS is not concerned with them, owing to the rule in Turquin's case, and Messrs. Jones and Harter's ostensible authority is not undermined.
Yes.
It's not saying that their lack of authority was cured by board ratification.
No, absolutely, absolutely. You're absolutely right. But if you go on to issue 3, it makes it plain as a pikestaff. In our respectful submission, well, it's certainly clear to me that we're saying that it's not avoidable by reason of a want of ostensible authority, i.e. the ostensible authority is not undermined, and we're entitled to rely on Turquin's case in relation to declarations of interest and the proceedings at the meeting, because the declaration of interest, as my lords and my lady will certainly have seen, is to be made at the meeting at which the business is to be transacted.
Yep.
And so this can only, on a proper and fair reading of this, it can only relate to the meeting. And it was the meeting at which there was ratification. And we say that the HOA, for those reasons, is not avoidable by EACL, for both of those reasons. My lords and my lady, as you well know, the rule in Turquin's case is not a case relevant to the issue of a sensible authority. It is relevant to the proceedings at board meetings, and it is the indoor management principle. That is to say, the third party cannot be taken and does not have to investigate whether proceedings at board meetings were readily taken. That is what the rule is all about. And so where the discussion at rule and Turkle's case can only, and certainly I had no doubt about it until my friend raised the issue just a few moments ago, that this was an argument to address. I understand Justice of Appeal Clark seemed to conflate the two issues, but as far as a company lawyer is concerned, Turkle is concerned with procedural regularity at board meetings.
I'm not sure where we've got to. I mean, I understand Mr. Howard's not saying he's prejudiced about it. We spent half an hour trying to work out what you're arguing about. Wouldn't it be better to let you get on and argue it and see where we get to? Well, it's not going to add very much to the time, is it?
I think we'll adjourn for a minute or two just to discuss this. Mr. Todd, we have sympathy with Mr. Howard's submission that the point wasn't squarely raised in your written argument, that in the absence of prejudice, we would let it in. What we're going to do is allow you to develop the argument, and we will review the situation. We're preserving Mr. Howard's position meantime, just in case any prejudice does emerge, but on the assumption that he's able to deal with the point, then we will deal with it also.
Grateful. I'd got to the bottom of the first page of my submissions. I hope I won't repeat those. Perhaps I can just do it very, very quickly. We say the sale was effected by the heads of agreement 27th of February and a transfer date of the 1st of March, and or the ratification of that sale and transfer at a board meeting of the 1st of March. Of course, if the court accepts, and I think this is the concern which has stirred Mr. Howard to his feet, if the court accepts that the sale was validly ratified and hence adopted by EACL at the board meeting on the 1st of March, it matters not whether Mr. Jones had any authority, actual or ostensible, when he executed the heads of agreement and transfer. Fourthly, we say, of course, any such ratification is well established. Any such ratification or adoption by the principal does not have to be communicated to the third party or contractor, or indeed to the agent for it to be effective.
But that makes it sound as though that's actual valid ratification.
That's a valid ratification.
So are you saying that there was valid ratification, yes, notwithstanding the non-declaration of interest?
Oh yes, that's Turkle.
That's
my Turkle case, yes.
No, sorry, I thought your Turkle case was Satria was entitled to assume that there had been valid ratification.
Yes.
But what you now seem to be saying is, in fact, internally, there was valid ratification, and since there was, that didn't need to be communicated to anyone. That's what you seem to be saying.
What I say is this. What we say is this: that there was ratification at the board meeting, that PT Satria did not know of any alleged irregularity.
And I'm so sorry to interrupt, but when you say there was ratification at the board meeting, is it your case on this appeal that there was valid ratification,
yes,
notwithstanding the conflict of interest of the directors?
Yes.
That is your case?
Yes, it
right.
is. Yes, it is. There was a valid meeting. The Court of Appeal accepted there was a valid meeting on the 1st of March. The questions of declaration of interest on our case and the fullness of the information supplied, which was really the other issue upon which the Court of Appeal relied, we say those are entirely internal matters for EACL, for the board at EACL. And it matters to us. We're not bound to inquire whether the procedures for declaration of interest and the provision of information were satisfied.
It is my fault, but
No?
I am left rather unsure from your answer what you are saying, because the latter part drifts off into what Satria was entitled to assume, which in my mind, I could be wrong, is the Turkwan rule. That's what a third party dealing with the company is entitled to assume has been done within the company.
Yes.
So that's really looking at things from the outside. But the reason for my question to you before was looking at matters from the point of view of the company itself, from the inside. Are you saying that so far as the company itself, and I'm now talking about EACL, there was valid ratification at the board meeting, notwithstanding the conflicts of interest of the directors?
What I am saying, yes, my Lord, yes, I am saying that. My Lord,
Right.
I am saying that. Have a look at the note of this exchange when we have a moment and come back to you on that. But that's the case.
So again, forgive me for going on about this,
No.
just so I'm clear. You're saying two things. There was valid ratification, notwithstanding the conflict of interest, as a matter of the management by EACL of its own affairs.
Yes.
And further and alternatively, Satria was entitled to rely on the rule in Turkwan's case in relation to what had happened, even if there hadn't been valid ratification.
Even if there hadn't been valid ratification.
You're saying both those things?
Yes.
All right, thank you.
It was entitled, indeed. So upon just the final point of my overview, if I may, upon the sale becoming effective, whether pursuant to Mr. Jonio's sensible authority to conclude the sale or upon its ratification and adoption at the board meeting of the 1st of March, upon that happening, the effect is as follows, that PT Satria, as you would know, would become the beneficial owner of the shares in BEL. EACL would thereupon become a bare trustee of those shares, and PT Satria would be entitled as against the EACL to registration as the legal owner of those shares. They're the legal consequences of the valid sale, either by means of a sensible authority or by ratification. Now, the Court of Appeal's judgment, my lords and my lady, is at Bundle 1 at page 44. And the Court of Appeal held, and by way of summary, if I can take you to, or invite you to, or just, it's at paragraph 172 at page 113, Bundle 1, page 113. The Court of Appeal held that Mr. Jones had no authority, actual or ostensible, to enter into the heads of agreement. And it held that whilst the agreement, whilst the meeting of the 1st of March of EACL was duly convened, the resolution ratifying or adopting the sale was of no effect. Because, he said, the Court of Appeal said, and this is Justice Appeal Clerk, the directors present, Mr. Jones and Mr. Hart, had failed to declare their interest in the sale. Details of the transaction were not tabled at the board meeting of EACL, and the instrument of transfer presented to the meeting was not a proper instrument of transfer capable of being approved. As to the Court of Appeal judgment, what we say is this. As to the first of those points, authority, our case is that Mr. Jones had a sensible authority to enter into the heads of agreement. As to the second of those points, we say, that is ratification, in relation to the declaration of interest and the tabling of information, so those 2 points, we say the meeting had been duly convened. Mr. Yamori did not attend for whatever reason. He had, as you'll have seen from the judgment, he had rejected attending the meeting by Skype. And he was therefore not present to participate or to hear any formal declaration of interest or to learn from anything which may have been tabled at the meeting. And as the Court of Appeal said at paragraph 86 page 74 of Bundle 1, the last sentence, it's for the directors to attend if they wish to be involved in any consideration of a transfer of shares in BEL. So the Court of Appeal held that it was a valid meeting, and really it was up to Mr. Yamor if he chose not to attend. Effectively, the complaint is that at the validly convened board meeting, attended only by them, but only by Mr. Jones and Mr. Harter, they did not formally declare to themselves their interest in the transaction, and secondly, did not table at that meeting that which they already knew. The terms of their interest, of course, in the transaction were plain as a pikestaff, were clear from the terms of the heads of agreement, because it is those liabilities to them which the Court of Appeal said should have been declared, or the payment of the liabilities to them, which should have been declared.
Was a notice at the meeting the only way in which the interest could have been declared?
No, they could have been declared informally. I'm sorry, lady, I do beg your pardon. I need to just check with the bylaws on that. And that's at Bundle 5. And sorry, Phil. 1711 is the first page of those, and it's Article 52. These are the EACL bylaws.
Sorry, what document are you taking us to?
I'm taking to the EACL bylaws.
Oh, right.
And it's starting at 1711, and I'm picking it up at Article 52 on page 1732. Conflicts of interest. Any director or any director's firm, partner, or any company with whom any director is associated may act in any capacity for be employed by or render services to the company, and such director or such director's firm, partner, or company shall be entitled to remuneration as if such director were not a director. Nothing herein contained shall authorise a director or director's firm, partner, or company to act as auditor. 52.2. A director who is directly or indirectly interested in a contract or proposed contract or arrangement with the company shall declare the nature of such interest as required by the Act, following a declaration being made pursuant to this bylaw, and unless disqualified by the chairman. Have you got a copy of the Act? Following a declaration being made pursuant to this bylaw, and unless disqualified by the chairman of the relevant board meeting, a director may vote in respect of any contract or proposed contract or arrangement in which such director is interested, and may be counted in the quorum for such meeting. At Bundle 9, tab 32, is the Bermuda Companies Act in 1981. And section 97, you will find page 100 and... I'm sorry, 107. Yes, at page 2944. Is it? And if I... No, that's not it. Sorry.
That's duty of care of officers?
Yes.
Yeah, no.
Is that what the one you meant?
I'm sorry.
Section 97 is duty of care of officers?
Yes, no, that is not what I was...
Yes, it is.
It's subsection 4B.
Sorry, 4B, I'm sorry. Yes, I'm so sorry. 97, 4B, without in any way limiting the generality of subsection 1, an officer of a company shall be deemed not to be acting honestly and in good faith if B, he fails to disclose at the first opportunity at a meeting of directors or by writing to the directors his interest in any material contract or proposed material contract with the company or any of its subsidiaries, and his material interest in any person that is a party to a material contract or proposed material contract with the company or any of its subsidiaries. Well, my Lord, the heads of agreement, of course, my lords and my lady, which
But
you
just before we
will,
read that, don't we need subsection 5A as well?
my lady, thank you. For the purpose of this section, a general notice to the directors of a company a general notice to the director of the company by an officer of the company declaring that he is an officer of or has a material interest in a person and is to be regarded as interested in any contract with that person is a sufficient declaration of interest in any such contract.
That doesn't cover this case, though, does it? Here the conflict doesn't arise from an interest in a person, but rather from the guarantee of payment of a debt.
It's the debts. That's why... Heads agreement, yeah. And what I was going to take, my lords and my lady, to...
Sorry, if you're moving away, are you coming back to section 97 to address further argument on it, or if not?
I was going to take you to the heads of agreement, but if...
All right, well, in that case, don't you need section 97(1) as well? Because 4 is without limiting the generality of subsection 1. You have to act honestly and in good faith with a view to the best interests of the company.
Yes.
You seem to be suggesting that it's good enough for the two interested directors to declare to themselves their interest, knowing that no other director knows about that.
No,
Might it not be said that it's in the best interest of the company that someone else knows about it, viz. Another director?
I'm not saying that.
Oh, then I have misunderstood what.
No, I've not made myself clear enough.
All right.
My Lord, what I'm saying is this, that let's pick it up at 97(1). Every officer of the company must act honestly and in good faith with a view to the best interests of the company. Now, we will be addressing, we hope to be addressing you in due course on whether or not this was an unusual transaction and why it's quite clear that this was in the best interests of the company. But leaving that aside, so I do not accept that Mr. Jones and Mr. Harter were acting otherwise, and that the court didn't find that they were acting otherwise than in the best interests of the company, EACL.
I was suggesting that it might be thought that it's in the best interest of the company that someone other than the two directors who have a personal interest in the contract is made aware of their interest so that they can take an issue on it if they want to.
And indeed, Mr. Yamura was given notice of the meeting on the 1st of March and chose not to attend.
Well, I don't think we've seen the notice of the meeting, but did that include notice that Mr. Hatter and Mr. Jones were going to give notice of their interest?
No, it didn't. It did not. But it did say the Court of Appeal addressed this question about whether or not the meeting had been validly convened. It did not. Your Lordship is absolutely right. It did not contain an express statement to the effect that a declaration of interest was to be made. But it's unusual for a notice of meeting to.
That may be so, but I come back to the point that I was asking about. I had understood when you started saying, in relation to the ratification point, that the complaint is that Mr. Jones and Mr. Hatter did not make a declaration to themselves, the suggestion being, well, how ridiculous that they should have to declare their interest to themselves, they know about it already. And I was asking you, in the light of that submission, might it not be said by reference to section 97, which is cross-referred to from the bylaws, that they should have appreciated that it would be in the best interest of the company that another director, not interested in the contract that they were seeking to ratify at this meeting, was made aware if necessary by some other means than attendance at the meeting, of their interest in the contract.
Lord, I don't accept that as a proposition of law. I don't accept that. Mr. Yamura is quite clear, was the director of both BEL and of EACL. The court's accepted, and I think it's accepted in our statements of facts and issues, that Mr. Yamura didn't take any part in any of the activities of either BEL or EACL. What happened is he was given notice. He was given notice of a board meeting, and he chose not to attend. But, my lord, I take your point. Your lordship may say that it would have been better had they expressly identified the fact that they were, on the 1st of March 2015, going to make a declaration of interest in a contract. But, my lord, they didn't do that. But, my lord, that was they.
Or tell the company by the other director by some other means.
That was Mr. Yamura, yes.
Yeah.
Lord, Lord, I must accept that they didn't do that, but that in my respectful submission, does not mean that the absence of, the failure to do so, does not mean that Mr. Jones and Mr. Harter were not acting honestly and in good faith with a view to the best interests of the company.
May I take you back to section
Yes.
97, subsection 4b?
Yes.
Because does this, may it be said that this provides that a director is not acting honestly and in good faith if he fails to disclose at the first opportunity
Yes.
at a meeting of directors or by writing to the directors his interest in any contract? And in this particular case, when was that
The
disclosed?
first opportunity was the first board meeting coming up after the heads of agreement was the 1st of March.
You say that was the first opportunity?
After the heads of agreement, yes.
And if another director chooses not to attend that board meeting, you say that it is this subsection is satisfied because those attending knew of it.
Yes,
but the person absent didn't.
They had countersigned the heads of agreement, yes.
Thank you.
We have to look at all this, don't we, in the context of the circumstances of the case, which we know to be the directors divided into two opposing camps, and effectively one camp are entering into a contract in which they have a personal interest, and the other camp are not being made aware of that.
Lord, I hear what you say about that. My Lord, the position, that is the way that it was, that was the way it was explained, that the two camps were explained by the judge and by the Court of Appeal. I accept that. I accept that. I have to accept that. But, my Lord, what I say is that in relation, and of course you will have seen the reference to Neptune vehicle washing, the decision of Mr. Justice Lightman at first instance, that a director, in declaring his interest, has to declare to himself the interest that he has in the transaction which he's going to enter into. It's a decision of Mr. Justice Lightman. It's always left me slightly cold, but it is, and I don't think it's been expressly followed.
Sorry, is that where he's the only director?
Yes, he's the only.
He's the only possible recipient of that notice.
Absolutely.
Not our case.
No, it's not. It's no. You're absolutely right. But the only two attending the meeting, you. The only two who chose to attend the meeting, you.
I think the 2006 Act takes a different view.
It does. Fortunately. So, where was I? My Lord, I'm aware of the fact you...
No, sorry, I just wanted to ask you about section 97(1). You've dealt with that. Thank you very much.
I'm grateful. We say that PT Satria knew nothing about any such failures, and indeed, as the Court of Appeal found, we probably didn't even know of the meeting. So when I say we, I mean PT Satria. And that's, I think, at paragraph 140 of the Court of Appeal judgment.
Sorry, 140.
140. Yes, one point. In my view, PT Satria was put on inquiry. It was obvious that Jonas, well, Mr. Jonas, Mr. Hart, he seems to forget Mr., stood to gain from the heads of agreement monies, which, although due to them from BEL, would otherwise probably not be paid. There was no indication when the heads of agreement was made that there had been any declaration of interest, and after it was made, there was no indication their interests had been declared at the board meeting on the 1st of March. It's not clear that PT Satria ever saw the minutes of that meeting or was aware that it was taking place, or by notice to all directors.
And I think you just told us positively that they weren't aware that it had taken place. Is that right? Well, then how does the Turkwind rule assist you in relation to ratification? Because if they weren't aware that the meeting to ratify had taken place, how could they assume that there had been a valid ratification at that meeting of which they were not aware?
The rule in Turkwind's case is such that where a board passes a resolution or transacts business, providing that a third party does not know of any irregularity in the transaction of that business, then he can assume, he is entitled to assume, it can't be taken against him. It can't be taken against him that the business was not regularly transacted. That's why I put it.
Thank you.
I'm moving back to my overview. The proper instruments of transfer, which was the second, which is the another point upon which the Court of Appeal said that the ratification could not have taken place. In relation to that, that's one of the issues towards the end of our issues. It's what is meant by a proper instrument of transfer. It's a very short point. We deal with it, I think it's issue 4. Issue 4 in our case. We deal with it there, it's the Paradise Motor Co. case, as to what the meaning of a proper instrument of transfer means. And we say it's one that's capable of being stamped. That's the meaning to be attributed to that. I'm not going to go into that now. When I come, because I know I'm now going to be short of time, I'm going to say, well, I'm not going to add, I'm not going to take you, I'm not abandoning points 4, 5, 6 and 7, but there's nothing I wish to add to our written case on those. What the Court of Appeal found, it wasn't, or suggested that it wasn't a proper instrument of, a transfer was not a proper instrument of transfer unless, perhaps I just give you the reference to that. Where's it? Whilst Mr. Gillian is looking for that, yes, he deals with paragraph 147 of the judgment, proper instrument of transfer. And what he says at page 1, paragraph 154 at page 106 of bundle 1. 152, paragraph 152 at page 106. It's common ground the registration of the transfer in the present case required the consent of the Bermuda Monetary Authority. Oh, I'm sorry.
I think it's 148 that he might be intending.
Sorry, I'm really grateful to my friend. The instrument of transfer in this case was executed pursuant to a purported decision of the board of EACL. The board was inquirate and the resolution ineffectual. In those circumstances, the share transfer relied on cannot be regarded as a proper instrument of transfer. It was accordingly unlawful for BEL to register PT Satria as the shareholder. when we say that a proper instrument of transfer is one that is capable of stamping, and that's the proper meaning to be attributed to those words. The substantive issues, having...
I'm not going to make a habit of rising to the end. I wonder whether this issue is actually one that even arises on the case, in this sense. If the Court of Appeal's judgment is right on no ostensible authority and no ratification, as I understand it, then there is no... The PT Satria don't claim any entitlement to the shares. So this issue about proper instrument of transfer doesn't arise, unless Mr. Todd is saying, well, somehow we're entitled, because there is a document called an instrument of transfer, to the shares.
I agree.
So I think that a lot of these subsequent issues...
So you're not taking a point about it, saying it's not a proper instrument?
We just rely on what the Court of Appeal said. It just followed from, as Lord Justice Clark, or Justice of Appeal Clark, said, it just followed as a consequence of the prior finding.
No, they're saying it's an element of a proper instrument of transfer that it's duly authorised. They're saying that is within the statutory meaning.
But, I mean, that doesn't really matter.
Yeah,
but it is properly authorised or it isn't.
Yes, I mean, that's what I'm saying. If it's authorised, then it's a proper instrument. But if it's not authorised, then it's just a nullity.
So we needn't concern ourselves with the statutory meaning of proper instrument?
I don't think so. I don't think there's really an issue.
No. Well, I think the Court of Appeal thought there was.
But I don't think they did. I don't think they were there saying anything other than this follows from what we've said.
But just to be clear, are you saying if you lose on the ostensible authority point and the ratification point, that this would qualify as a proper instrument of... So you're right.
Yeah, that's very helpful. Thank you.
Follow that.
Yes.
Yes.
Well, it's 148 of the Court of Appeal's judgment where they wrap it up into the statutory interpretation, but you're not taking the point. Good.
That's one point less my lords and my lady need to deal with then. I'm grateful to my friend for that. The substantive issues, the way I was having that brief introduction, the way I wish to deal with the issues is really under four broad headings, if I may. I'm going to give you a bit of a roadmap as to where I'm going, if that would be helpful. Yes. What we're saying here, and in giving you this broad map, it's not. I'm not going to say that this formulation contains every single issue that arises. So it's just for the purpose of my submissions today. This is the roadmap. The first thing I will address is whether Mr. Jones was held out by EACL to conclude the sale, i.e. a sensible authority or apparent authority, however you wish to describe it. The second issue I'll address, or the second set of submissions is whether Mr. Jones' apparent authority, if he had it, is affected in some way by the nature of the sale of this kind, of this class of transaction. The third way I'd like to address this is whether the concept of being put on inquiry is relevant to a determination of the existence of ostensible authority. And then finally, the fourth area is whether PT Satria was in fact put on inquiry so as to avoid the sale. And that's where I'd like to address. So I hope that gives you some guidance of where I'm intending to go.
Yes, thank you.
Thank you. Ostensible authority is, I apologise for putting this, but it is important, I think, when you look at the Court of Appeal judgment as a whole. I think one has to bear in mind that ostensible authority or apparent authority is, as the name suggests, concerned with outward appearances to outsiders or third parties. That's an obvious point, but it is important. It's a concept, we say, designed for the protection of third parties upon a holding out by the principle that the agent has the authority he appears to have. That is, we say, it's not really a concept designed for the benefit of the principal, because if the principal wants to be bound, he can give the give actual authority. It is clearly a concept designed for the benefit of outsiders, third parties, to whom a representation has been made. And it's that point, as to for whose protection this concept exists, which indicates, we suggest, the differences in approach of the judge at first instance and the Court of Appeal. The court will have in mind, this court will have in mind, that neither P.T. Satria nor Mr. Suhadano is in any sense a wrongdoer. There was no finding of any wrongdoing or underhand conduct on the part of either of them. The Court of Appeal seems to have thought that Mr. Jones and Mr. Harter were motivated in their actions by their own self-interest. But that's certainly not the case with Mr. Suhadano. Indeed, he had been asked, and the Court of Appeal judgment referred to this, he had been asked by the Indonesian government to assist in saving the project which BEL had embarked upon. And that's the Court of Appeal at paragraph 24, at bundle 1, page 53. Yes, it's the third sentence. But starting at the beginning, when P.T. Satria heard that PBS had terminated the MOU, it contacted BEL to discuss reopening talks. This was in December 2014. Mr. Suhadano gave evidence that this was because the Indonesian government had asked him to intervene and take what was potentially a failing project in hand. He said the government had confidence in him because he had previously done just that with two geothermal energy projects, which were substantially larger than this one. He referred to it as a trash project. And that, the project, as we know, with BEL, which BEL had, involved two government contracts. One was to develop the plant, and the other was then to supply energy from that plant. Yet what we submit is that the Court of Appeal, notwithstanding this was the case in a sensible authority, failed to have any regard at all to the impact of the holding out on P.T. Satria, who was, and is, we say, an innocent third party. Indeed, the Court of Appeal seems to have focused primarily on issues as between EACL and Mr. Jones, which are issues which we say go to actual authority and not to ostensible authority. And in that sense, we submit to you that the Court of Appeal was looking at the case from the wrong end of the telescope. It should have been more concerned with P.T. Satria's perception as to the authority of Mr. Jones and Mr. Harter. And a good example of the Court of Appeal's approach can be found in particular at paragraph 110, bundle 1, pages 86 to 88. We deal with those points subsequently. I will come back to them, but you can just pick up one or two of them before you go to page 86. There are several factors. I'm not going to go over these all now. We deal with them actually in our case. We deal with them in our case at it's bundle 6. At page 1852, in our paragraphs 15 to 18. Perhaps it's as well to have that open at the same time. 18. Yes, what we say, if you have that together with the Court of Appeal judgment, if I can ask you to have them both open, we say at para 110, the Court of Appeal set out 8 factors which they considered militate against Mr. Jones and Mr. Harter, or Mr. Jones and Mr. Harter, having had ostensible authority to enter into the heads of agreement on behalf of the EACL. However, on proper analysis, they don't really support the Court of Appeal's reversal of the judge's finding that Mr. Jones had ostensible authority to enter into the heads of agreement. Factors 1 to 3 inclusive are relevant to the question of whether Mr. Jones had actual rather than ostensible authority. They do not undermine Satria's case that Mr. Jones was held out as being authorised to act on his behalf. So I'd invite you just to I'm going to come back to these points, but those are the references. And I say they indicate an approach of the Court of Appeal, looking at this issue of a sensible authority from entirely the wrong end of the telescope. And therefore, and in doing so, they got it wrong. Now, my lords and my lady, if I may continue, I'd say we're going to come back to those factors later, but you have the reference if I run out of time. The conditions which must be, it is well known, the conditions which must be fulfilled in order for a third party to be able to rely on ostensible authority are those which are set out by Lord Justice Diplock in Freeman and Lockyer. They're the often oft-cited principles. You find that at bundle 7. And it's at tab 1. It's at page 1937. I'm sure you have them all in mind. Top of the page, representation that the agent had authority to enter on behalf of the company into a contract of the kind sought to be enforced. Not a particular contract, but of the kind. But such representation was made by a person who had actual authority to manage the business of the company, or in respect of those matters to which the contract relates. Thirdly, that he, the contractor, third party, was induced by such representation to enter into the contract, and that under its memorandum and articles, the company was not deprived of the capacity either to enter into a contract of the kind sought to be enforced or to delegate authority to enter into a contract of that kind. And then just going down the bottom, whilst I'm on that page, if you go to, if I may invite your attention, my lords and my lady, to the start of the final paragraph, about 2/3 of the way down. In each of the relevant cases, the representation relied upon as creating the apparent authority of the agent was by conduct in permitting the agent to act in the management and conduct of the part of the business of the company. Those I know you're well aware of those principles, but really what I just invite you to note in particular is that we're looking to see whether these agents or these purported agents had authority to enter into a contract of this kind. That is, something, a refinancing or a sale of BEL, that's what we say, is a contract of this kind. The representation, we say, was made, the representation was made, was that Mr. Jones had authority on behalf of EACL to enter into the contract, the nature of the heads of agreement, that is, a transaction involving the introduction of a suitable investment partner and or a buyer of BEL. And we say that that representation was made, that representation holding out was made by EACL, and it was done by its board of directors. Mr. Jones and Mr. Harter being actively involved in that sale, and the only other director, Mr. Yamura, part of the Watabi camp, as my Lord Breed has already pointed out, but who was, on the findings of the Court of Appeal, a rather disinterested non-executive director, who left the affairs of EACL entirely to Mr. Jones and Mr. Harter. He acquiesced in them carrying on the business of EACL to them entirely. So he acquiesced in it, he permitted it to be done, its affairs to be managed in that way. And there's no evidence that Mr. Yamura played any part whatsoever in the affairs of EACL. EACL, it's important, EACL was, as you will know, in any event, solely a holding company, the sole asset of which was BEL. And the judge found, and it's in our statement of facts and issues, that Mr. Yamura played no part in the affairs of BEL, which was the active trading company. So I say EACL was simply a holding company. It's our statement of facts and issues paragraphs 12 to 14 at 6, bundle 6, 1820. And then the Court of Appeal judgment at 86, paragraph 86, page 74 of bundle 1. Fine. That's the bit which I've referred you to before. I'm at 86, at page 74 of bundle 1. I'm not persuaded that the judge's conclusion in this respect was wrong. The agenda made plain that share transfer, cancellation, approval were to be discussed. That was apt to include a transfer of shares in BEL. No shares in EACL had been transferred. Further, item 5 was any other business, which would prima facie embrace any business that the board could lawfully conclude. For example, I suppose, receiving a declaration of interest. In Darmy, the court considered that the absence of a provision such as to transact such other business as may lawfully be lawfully brought forward was significant. Those circumstances, it was for the directors to attend if they wished to be involved in any consideration of a transfer of shares in BEL, and that's what the Court of Appeal found. Mr. Uramura chose to stay away. And how the representation obviously was made to PT Satria, acting by Mr. Suhadano, sole director and 85% shareholder of PT Satria. How it was made, we submit that it was made by conduct, and that by that conduct, it appeared to PT Satria that Mr. Jones was authorised to act on behalf of EACL, and in particular to enter into a contract of the nature of the HOA. Importantly, as we say in paragraph 39 of our case, no restriction or limitation on Mr. Jones or Mr. Harter's authority was ever communicated to PT Satria. And that's paragraph 39 of our case, which is at bundle 6 at 1861. When I then move on, that's
in relation to C, I mean, the point made against you, I think, the point made by the Court of Appeal was that PTS were aware of the bylaws of EACL.
Yes, they were. Sorry, would you like? Yes, they were.
Which themselves limited the powers of directors and required some types of decision to be taken by the board.
Absolutely. Shall I deal with that point now? We have addressed that point. May I just? I can do it by reference. I don't need my notes on this. I've spent a little time looking at this. The bylaws are at 1711. I think they start, don't they? At bundle 5. Let's just see what it is that PT Satria would see, what they'd be aware of. Can I do it by, if I may do it this way, page turning, so from the start. So I'm going to start at 1714, if I may. I'm going to look at interpretation. And firstly, board. I'm sorry, Melody. So, definition of board. The board of directors, it means the board of directors appointed or elected pursuant to these bylaws, we know that's the 3 of them, and acting by resolution in accordance with the Act and these bylaws, or the directors present at a meeting of directors of which there is a quorum. So you will know immediately then when the articles refer to a board, it's directors transact their business at a meeting of which there is a quorum. Directors is a defined term, inevitably, 2 down, which nothing turns on that. I'm then going to go on, if I may, to directors. So I'm going to go to 38, please, number of directors, which is at page 1729. And what you see from that is number of directors. The board shall consist of not less than 2, or such number in excess of as the directors may determine. We know that's 3. No dispute about that. Term of office. Directors shall hold office to such term as the members may determine, or in the absence of such determination, until the next annual general meeting, or until their successors are elected or appointed, or their office is otherwise vacated.
Is it accepted that Satria knew there were 3 directors?
Yes, it is. My lady, it is. They had done due diligence, as the Court of Appeal rightly pointed out. If I may then go on to 45, Article 45 at 1731. Directors to manage business. The business of the company shall be managed and conducted by the board, and that's why I referred you to the definition at the outset. The board. That's the board acting by a resolution of those at a meeting at which a quorum is present. In managing the business of the company, the board may exercise all such powers of the company, as are not by the Act or by these bylaws required to be exercised by the company in general meeting. Now, the sale of the asset, the sale of BEL, was not a matter which was reserved to the company in general meeting. It's not suggested it was. When I say company general meeting, I mean EACL in general meeting. And then we've looked a little at conflicts, and we're going over then, if I may please, to meetings of the Board of Directors at Article 54, Bylaw 54, on page 1734 of this same bundle. The Board may meet for the transaction of business, adjourn and otherwise regulate its meetings as it sees fit. A resolution put to the vote at a meeting of the Board shall be carried on by the affirmative votes of a majority of the votes cast, and in the case of an equality of votes, the resolution shall fail. So Mr. Sardana will know that there needs to be a majority of directors in favour of any transaction of business, of any business transacted. So if he knows that Mr. Jones and Mr. Harter are in favour, he knows he's got 2 out of 3. So his due diligence doesn't disqualify him, as the Court of Appeal suggested. In fact, quite the opposite. He can rely on there being 2 directors being in favour, because he will know that at a duly convened board meeting, they will carry the day. And then we see in Article 50, Bylaw 57, the quorum necessary for the transaction of business at a meeting of the board shall be 2 directors. You don't even need to have the 3 there for it to be a valid board meeting. So Mr. Sardana will have known there are 3 directors. The board can transact all the business of the company which isn't reserved. There is no reservation to the company in general meeting or EACL in general meeting in relation to dealings in the company's sole asset. The board can deal with it. It can deal with it at a meeting. The quorum at a meeting is 2 out of 3, and a resolution is passed by a majority. And so, and he knows he's got the assent, at least, of 2. He knows he's got Jones and Harter, and that they're in favour of the transaction. And that's what he would have known from his due diligence. So, with the greatest respect to the Court of Appeal in Bermuda, Justice of Appeal Clark got it plainly wrong.
In fact, the Court of Appeal's judgment means that Satria is worse off than the normal person dealing with an exempted private company in Bermuda, because there is no registration of the bylaws. Absolutely,
absolutely. Your ladyship's absolutely right. That wasn't a finding, I think, in the judgment, but your ladyship is in fact right. But having seen the bylaws, what can you expect? Well, as long as I'm dealing with 2 directors, they can convene a meeting. They can be the only 2 people at the meeting, and they can transact the business. And the question then is, the second issue, which I was going to come on to in my roadmap, if my lords and my lady remember that at the, I was going to say the outset of my submissions, it was about half an hour ago or so, is whether Mr. Jono's apparent or ostensible authority is affected by the nature of this sale. What our case is this, my lords and my lady, the nature, we accept that the nature of the transaction in question is relevant to the issue of ostensible authority. But we say this sale, in these circumstances, was not an unusual transaction. And we'll make that good. Thirdly, we say the representation as to Mr. Jono's authority having been made, PT Satria was not bound to investigate the representation as to Mr. Jono's authority further. And for that, we rely on Akai in the Court of Final Appeal of Hong Kong. That you will find at Bundle 7 at tab 12. This is an authority which Mr. Howard says, if necessary, he will say it's inconsistent with earlier authority, and I'll show, in fact, it isn't. But let's, the bit I want to refer to now is at paragraph 52 of this judgment. That's at page 2162. You'll see just at page 2139, however, the constitution of this court, and if I may respectfully say so, a very eminent court indeed, the Chief Justice in Hong Kong, Justice Bakari Chan, that's Patrick Chan, of course, and Mr. Justice Ribeiro, and then Lord Neuberger, a very distinguished panel to determine this case. And it was Lord Neuberger who gave the judgment in this case. And you will see the counsel, or one Mr. Sumption and one Mr. Cosmin, doing battle over this matter. And I'm going to take you towards the paragraph 52 because I said I was going to. But this bit starts really at paragraph 49 on page 2161. The issue under consideration, or at least it is described by Lord Neuberger, as the state of mind of the person alleging apparent authority. For the bank, Mr. Sumption contended that unless the bank had actual knowledge of Mr. Ting's lack of authority or its belief that Mr. Ting had authority was dishonest or irrational, then the bank's state of mind will suffice for the purpose of establishing apparent authority. Mr. Sumption also accepted if the bank was reckless in its belief or if it was guilty of turning a blind eye, that would not do either on the basis that recklessness and blind eye ignorance amount to irrationality or dishonesty in this context. Mr. Cosmin, who appeared for Akai, argued that this set too low a standard on the bank as a third party seeking to establish apparent authority, and that apparent authority could not be relied on if the bank had failed to make the inquiries that a reasonable person would have made in the circumstances to verify the authority of Mr. Ting. And Lord Neuberger then, I just mentioned the first sentence in 50. I have some doubts as to the extent to which there would in practice be much difference in the outcome between the application of the rival tests. And he then in paragraph 51, approaching the issue by reference to both practicality and principle, I prefer the bank's submission. In terms of practicality at least, when it comes to normal commercial transactions, the application of the concept of constructive notice, which is what Akai's approach effectively involves, has been deprecated. See, for example, Lord Justice Scruton in Greer and Downs. and one can understand why. 52, in a commercial context, absent dishonesty or irrationality, a person should be entitled to rely on what he's told. This may occasionally produce harsh results, but enables people engaged in business to know where they stand. And then he goes on to talk about ostensible authority being a species of estoppel by representation, and so on. That's all I wish to take you to. At the moment, that case was followed in a Court of Appeal decision, which I think was handed in to you yesterday, my lords and my lady. Quinn. There's a decision in Quinn and CC Automotive. I think Lord Justice Gross gave the judgment, or the main judgment of the court, and it's 2010 EWCA Civ at 1412. The relevant paragraph, I'm not going to go to it myself, but the relevant paragraph for my lords and my ladies' note is at paragraph 23, particularly at sub-paragraph 2 of that. Now, so that's the way PT Satria puts its case. It had no knowledge of any want of authority. It wasn't acting irrationally. And it's entitled, therefore, to rely on the representation which was made to it by EACL. EACL's case, Mr. Howard's case, is that the transaction was of a highly unusual nature, so as not to fall within the usual or implied authority of a single director. He says within the usual or implied authority of a single director. You will have seen that the heads of terms were only signed by, the heads of agreement were only signed by Mr. Jones on behalf of EACL, but Mr. Harter also countersigned it, apparently on behalf of BEL, but the other director of EACL did sign that. He said also that the transaction had a number of unusual features which should have put PT Satria on inquiry as to Mr. Jono's authority. So Mr. Howard is not accepting. Mr. Howard is going down the Bermuda Court of Appeal route rather than the Akai route. That it's not a question of being put on inquiry, it's a question of do you know of the want of authority, knowledge, actual knowledge, or that which is equivalent to actual knowledge. And he says that PT Satria's attempt to present it as mere fundraising or a sale of assets is unreal. And that he says also that the put on inquiry issue is relevant to the question of both the issue of ostensible authority and the indoor management principle. Those latter 2 points are at bundle 6, paras 33, sub-para 4 and para 50. I will come back to look at why we say, as a matter of fact, this was not an unusual transaction in the circumstances. But I don't really want to break off now from my roadmap, if I may, just so that you can see which way, where my submissions are going. I'm going to go on, having told you what the issues are in relation to that second point, whether Mr. Jono's apparent authority is affected by the nature of this sale. I've taken you to Akai. I'm going to come back to the factual basis of my submission in due course. I'm now going to move on to the third issue which I gave you on my roadmap, whether the concept of being put on inquiry is relevant to a determination of the existence of ostensible authority. And I've already made this submission to my lords and my lady, that at least in the company law context, the put on inquiry issue is usually considered relevant to the application of the indoor management principle. It's not an issue which is relevant to authorization. PT Satria says that Akai makes clear that ostensible authority, and you've seen this is at para 49 and following of Akai, that ostensible authority of an agent is only defeated where the third party has actual knowledge of the agent's lack of authority, or the third party's professed belief that the agent had authority was itself dishonest, the belief was dishonest, or that the third party's alleged belief was irrational. You have seen, because I've taken you to paragraph 52 of ACAI, the rationale for that approach. It is commercial certainty. Indeed, in that sense, it has a lot to do with Turpin. Thirdly, we say this, that the cases are relied on for the proposition. Thirdly, ACAI makes clear at paragraph 57 of the judgment at page 2163 that the case is relied upon for the proposition that the put on inquiry issue is relevant to the ostensible authority issue, do not in fact or in law support that proposition. And he there refers to three authorities. One is Underwood. This is dealt with at ACAI paragraph 57. And I'll be coming back to Underwood in a moment, but just saying what ACAI says. What ACAI says, two of the three judgments of the English Court of Appeal decision of Underwood contain reference to negligence and being put on inquiry. And he gives the references to judgments of Lord Justices Banks and Scrutton. However, that was because the defendant had to rebut an allegation of negligence in order to rely on Section 82 of the Bills of Exchange Act. It is fair to say that Lord Justice Atkin's judgment contains a sentence which, read on its own, supports ACAI's argument. And then, but if considered in the context of Section 82 of the 1882 Act, I do not think it can fairly be regarded as a general statement of the law of apparent authority. So the Court of Final Appeal had considered that English Court of Appeal case, reviewed it, and found that it didn't, on analysis, support the proposition that being put on inquiry is sufficient to undermine ostensible authority of an agent. And then he goes at paragraph 58, he says, another English Court of Appeal decision relied on by ACAI is Houghton. There is no doubt, and you'll have seen that in the Court of Appeal judgment, the Court of Appeal relied on Houghton. Another Court of Appeal is Houghton. There is no doubt but that in that case, the test propounded by the court was that proposed by Mr. Cosmin. However, it was a case involving the so-called indoor management rule, also known as the rule in Turquin's case, decided at a time when a person dealing with a company was deemed to know of the terms of its memorandum and articles of association, which is, of course, no longer the law in Hong Kong or indeed England. Passage, and he gives a reference, in the judgment of Lord Justice Sargent indicates an acceptance of a difference between the indoor management rule and apparent authority. Now, where's Morris and Canson? Where's Morris and Canson referred to? What's it referred to here? And going over the page, we see a reference there to Dawson, Mr. Justice Dawson in Northside. I want to come back to that, if I may. If I may respectfully submit, a useful passage. But here, at paragraph 60, other cases relied on by the bank, which similarly concern the indoor management principle, including Morris and Canson and rolled steel products. So those cases, so the court found, or the Court of Final Appeal in Hong Kong found that those cases did not support the proposition that merely being put on inquiry is sufficient to undermine an apparent authority of an agent. It has to be something more. It has to be actual knowledge.
that case, there was actual knowledge, wasn't it?
I'm sorry?
In that case, there was actual knowledge.
Yes, there was.
Because they had the board minutes, which
Absolutely.
is accepted they didn't have it here.
Absolutely. In Houghton, whilst we're in bundle 7, just to see the way this was developed, in Houghton was, which was referred to paragraph 58 in ACI, was actually considered in Freeman and Lockyer. And in Freeman and Lockyer, which is at tab 1 of bundle 7, Lord Justice Wilmer dealt with that transaction, or dealt with that case at 1925 of the judgment. And what he says, if I pick it up, if I may invite your attention to 1924, the very last two lines, though I have no doubt that Ram's case has rightly decided on its own facts, I cannot agree with the view expressed by Mr. Justice Slade that the previous decisions of this court were conflicting. I do not think that when properly understood, the cases relied on by the defendant here are in conflict with the decision in British Thompson-Houston case, or with the principles which I have already stated. If I correctly understand them, the cases relied on by the defendants deal with a much narrower point. They were all cases of most unusual transactions. So cases of most unusual transactions, as I've accepted the nature of the case, can undermine or is relevant to the existence of apparent authority. But it's not relevant to the putting on inquiry. It's not authority for the proposition that putting on inquiry is sufficient to undermine, of itself, sufficient to undermine ostensible authority. So what he's saying is they were all cases of most unusual transactions, which would not be within what would ordinarily be expected to be the scope of the authority of the officer purporting to act on behalf of the company. That's almost like a usual authority. Does this agent is he held out as having the sort of authority that a duly authorised agent in his position would have? And in Houghton, as my lady has said, the third party was not in a position to allege that was not in a position to say that the alleged agent was acting within the scope of such authority as one in his position would be expected to possess. There is accordingly no ground for saying that the officer in question, the officer in question was in fact being held out by the company as having authority to perform the act relied on. Lord Justice Pearson deals with it at page 1930, and it's the final paragraph. Again, a single direct, it's the fourth line, sorry, picking it up at the first line. At the bottom paragraph, there was put forward an argument to the effect that if the company's articles contained a provision under which the Board of Directors might have authorised a single director to make a contract of an unusual character on behalf of the company, the conferring of that such authority would be a matter of internal management, and so on. And then Lord Justice Diplock at page 1938 also considered Houghton, and that's the final paragraph, where he says this. He says the cases where the claim failed, namely Houghton and Credit Bank and Rama, were all cases where the contract sought to be enforced was not one which a person occupying the position in relation to the company's business which the contractor knew that the agent occupied would normally be authorised to enter into on behalf of the company. The conduct of the Board of Directors in permitting the agent to occupy that position upon which the contractor relied thus did not of itself amount to representation. So that if you've got an unusual transaction, you don't even satisfy condition 1 of Lord Justice Diplock's conditions in Freeman and Lockyer. And then he goes on about a third of the way down the page. There's a line which starts with the word permitted, which is in the middle of a sentence. And he goes on, since this would involve proving that the representation on which he relied perhaps I do beg your pardon. May I go back up to the fourth line? The contractor, however, in each of these cases, sought to rely upon a provision of the articles giving to the board power to delegate wide authority to the agent, as entitling him to treat the conduct of the board as a representation that the agent had delegated to him, wider powers than those usually exercised by persons occupying the position in relation to the company's business, which the agent was in fact permitted by the board to occupy. Since this would involve proving that the representations on which he in fact relied as inducing him to enter into the contract comprised the articles of association of the company as well as the conduct of the board, it would be necessary for him to establish first that he knew the contents of the articles, that is, condition 3 was fulfilled, in respect of any representation contained in the articles, and secondly, the conduct of the board in the light of that knowledge will be understood by a reasonable man as a representation that the agent had authority to enter into the contract sought to be enforced, that is, condition 1 was fulfilled. The need to establish both these things was pointed out by Lord Justice Sargent in Houghton, which in a judgment concurred in by Lord Justice Atkin. As I'd read them, but his observations as I read them are directed only to a case where the contract sought to be enforced is not a contract of a kind which a person occupying the position which the agent was permitted by the board to occupy would normally be authorised to enter into on behalf of the company. So he really treats this as an unusual transaction point rather than a put on inquiry issue. That's the way that that's the way that Lord Justice Diplock is explaining Houghton as a condition 1 rather than anything to do with condition 3. As to Morris and Canson, I know some members of this panel will be well familiar with it. It's in that same bundle of authorities as that's bundle 7, at tab 7. It starts at page 2059. The facts are there set out. Can I just outline them for you briefly? I'm sure I've got these right. The company had 2 directors, a Mr. C and a Mr. K. You picked this up after having set out the 29 Act, the section 143. The company had 2 directors, Mr. C and Mr. K. Mr. C and a Mr. S claimed to hold a meeting. S was not, of course, a director. C and S claimed to hold a meeting at which S was appointed a director. In fact, it follows that S was never appointed because there's no valid board resolution, no valid board meeting. Having purported to appoint S as a director, C and S then purportedly, as directors, asked K, one of the original directors, to resign, and they proceeded to allot shares to S and to C. At the general meeting of the company, at a general meeting of the company at which all 3, C, K and S, were present, C and S purportedly confirmed the appointment of S as a director. Clearly that was not valid because S was not properly a member because the shares allotted to him were never validly allotted. But more importantly, at the end of the first year, no annual general meeting was held. And pursuant to the articles, at the first annual general meeting, all of the directors in office are due to retire by rotation. And it's quite clear from it's quite clear that if you fail to hold a meeting, and you get that from this case, get it from other cases as well, Consolidated Nickel Mines immediately springs to mind. If you fail to hold that first meeting, all of the directors who were due to retire by rotation actually are deemed to have retired by rotation. So at the end of the first year, at the last time in which the first annual general meeting could have been held, all the directors had retired by rotation. So the company had no directors. Subsequently, C and S purported to appoint M, that's Morris, as a director. This is C and S, as directors, purported to use their powers as directors to appoint Morris as another director. Clearly, that was an invalid appointment because there were no directors of the company. Then, C, S, and M purported to allot shares to C, S, and M. So there were no directors because of the failure to hold the first annual general meeting. The subsequent appointment, purportedly as directors by C&S of Mr. M, Mr. Morris, was invalid because C&S weren't directors. And therefore, when C, S and M, who weren't directors, purported to allot shares, that must have been invalid because they had no authority to do so on behalf of the company. Those are the facts. The issue in the case was who were the directors and shareholders of the company. You see that at 2060. You'll see the holding at the bottom of the page held that the invalid appointment of M, invalid appointment for the reasons I give, as a director, and the invalid allotment of shares to him were not validated by section 143 of the Act or Article 88, since they were designed as machinery to avoid questions being raised as to the validity of transactions where there had been a slip in the appointment of a director and not to override substantive provisions relating to such appointments. This was not a case where there was a defective appointment in the case of C and S, but one where after 1941, that's the first annual general meeting, there was no appointment of them as directors at all, so that their acts could not be validated. Further, the rule in Royal British Bank and Turkwand did not apply to the allotment of shares to M, since in the transaction he was himself purporting to act as a director. So Morris and Canson is fairly and squarely, is fairly and squarely a matter of indoor management. And so in Akai, at bundle 7, tab 12, at paragraph 60 at page 2164, Lord Newberg was clearly right, where he said other cases relied on by the bank which similarly concern the indoor management rule, including Morris and Canson, but it was an indoor management principle case. It wasn't looking at whether or not being put on the inquiry could in any sense undermine apparent authority of an agent. The other case they're referred to I can take you through this, but going back to tab 7, which is the Morris and Canson case, it's Lord Simmons giving the judgment or the main speech in the House. He starts at page 2067. And what he says at 2074, he deals with Turkwand. And he says, it's that final paragraph, my lords, I think this question admits of an easy answer. The so-called rule in Turkwand's case is, I think, correctly stated in Halsbury's laws. But persons contracting with a company and dealing in good faith may assume that acts within its constitution and powers have been properly and duly performed and are not bound to inquire whether acts of internal management have been regular. And he then says it's confident for the 3 directors of the company to allot its shares. 3 persons purporting to act as directors did allot its shares. Therefore, Morris, who acted in good faith, was entitled to treat the shares as validly allotted. Thus runs the argument which was put to the House in Morris and Canson. And Lord Simmons says, I leave aside the question, well, what in the application of the rule is the meaning of good faith, and whether Morris, according to the true meaning of those words, acted in good faith, and asks whether Morris can in any event bring himself within the scope of the rule. My lords, I think it is clear on principle that he cannot. In the transaction which he would sustain and Canson seeks to impeach, he, Morris, was himself acting as a director. It's clearly an indoor management case, as Lord Newberger appropriately characterised it. Then in rolled steel products, that's another case referred to in Akai by Lord Newberger in paragraph 60. The other is rolled steel, and rolled steel you'll find in another bundle of authorities, which I'm afraid is bundle 8, and it's tab 27. And it starts at 2687.
You know, the last case you took us to took 8 days in the House of Lords. This one took 12, by the look of things.
We're very grateful
Change
for being
days.
given the 2 days that you'll have.
Yes, these days that's a long hearing.
Absolutely. Things have speeded up a little bit, I fear. But we are grateful for the time we've got. Thank you. But in rolled steel products, what we say is that this was, in fact, an actual knowledge case. We say you get that from, because it was concerned with the knowledge of a company called Colville's. And you pick it up at, you pick this up at, this was, of course, I think this was this an application to amend this case? Yeah, this wasn't it? No, perhaps you will see you see at 2724 letter H, the signed minutes of the meeting of that day, a copy of which was subsequently supplied to Colville's solicitors, and indeed had been drafted.
Sorry, which page are we on?
I'm sorry, 2724. Beg your pardon. It's Lord Justice Slade. The signed minutes of the board meeting of that day, at letter H, a copy of which was subsequently supplied to Colville's solicitors, and indeed had been drafted by them, made no mention whatever of any declaration of a personal interest by Mr. Schenkman. So they knew of the irregularity because they'd drafted the minutes. They'd asked for these minutes. They'd clearly asked for the minutes because they drafted them. They weren't of their client, they were of the other side. They knew the resolution they wanted. Since Colville's and its legal advisors must be taken to have knowledge of the relevant provisions of the plaintiff's articles, they must also be taken to have known that the resolution could not have been validly passed unless Mr. Schenkman had duly declared his personal interest at that board meeting or a previous meeting. So in truth, it was a question of actual knowledge of the irregularity and is no assistance.
Well, if you read on,
yes,
below, between E and F on the next page, furthermore, even if persons contracting with a company do not have actual knowledge, they'll be precluded from relying on the rule if the circumstances were such as to put them on inquiry.
Also, I'm not sure it was an actual knowledge case because they were put on inquiry. They knew what the article said. They didn't know whether, in fact, a declaration had been made. The minutes didn't record it, but it could have done.
Your Lordship is absolutely right. But they knew what they knew. They knew of the form of the board minutes they wished to have.
I rather thought that the point being made was, you know that from the articles that a declaration has to be made. You know from the minutes that they omit to say whether a declaration was made. You ought to check that a declaration was made. That seems like a putting on inquiry situation.
Indeed, but what we submit to, I'm grateful to my Lord for that. I understand. I do understand, and I must accept that. But what I do say is this: but this is in connection with the Turquin, with the discussion of the Turquin principle, which you pick up at 2724, letter D.
The Court of Appeal is treating it as an issue of knowledge.
Yes, they are.
They must be taken to have known. That's line 3 on.
Yes. Yes.
They must be taken to have known because they drafted the minutes and they made no provision for a declaration of interest.
Yes. And they go on it, therefore, that if therefore the defence are to be allowed both to take and succeed on tokens points, this must mean that in the circumstances, they were as a matter of law entitled to assume, contrary to the fact and without further inquiry, that Mr. Shankman had duly declared his personal interest. And this contention might well have been unanswerable if the rule interquence case were an absolute and unqualified rule. But as the statement of the rule quoted above indicates, it is not. It's a rule which only applies in favour of persons dealing with the company in good faith if such persons have notice of the relevant irregularity, they cannot rely on the rule.
So is this, but on the next point, which my Lord Reid referred, is that the point with which Lord Neuberger was disagreeing in Akai? Perhaps not. Perhaps we could have a look at that over the lunch.
Indeed, I'm grateful. I think we, yes, if we could look at that over the
if you would,
over the lunch
just
break. What EACL says in its case at 61891 at paragraph 31, that it's common ground that a third party cannot rely upon the ostensible authority of an agent if he knows or has reason to believe that the agent had actual authority, or if he was put on inquiry as to that fact. As to that, we accept that knowledge or reason to believe are impediments, but that being put, because both are equivalent to not actual knowledge. But we do not accept, and never have accepted, that being put on inquiry is an impediment to a finding of apparent authority. Can I just show my lords and my lady how that develops? It is said this is in paragraph 31 of EACL's case at 1891. Where they say it appears to be a common ground that as a matter of English law, a third party cannot rely on the ostensible authority of an agent if he knows or has reason to believe, query what is meant by reason to believe, that the agent had no actual authority, or if he was put on inquiry as to that fact. And that refers to footnote 42, and it refers to our written case at paragraph 47. And that you will find at 1863 of this same bundle 6.
I think it's 44 and 47, isn't it? 44 seems
Sorry, yes, it is.
directly.
So, absolutely, thank you. But 44, what we say is this: a person dealing with an agent will be precluded from relying on the agent's ostensible authority if the person knows or has reason to believe that the agent did not have actual authority, because that's what you get in criterion properties. But we say that's equivalent to actual authority. That's equivalent to actual knowledge. Having seen the witnesses and heard the evidence over attending, that goes on to what Mr. Justice Hellman found. And then in 47 we say this: Mr. Justice Hellman was well placed to determine whether P.T. Satria knew or had reason to believe, or was put on inquiry, as Justice of Appeal Clark put it. And we're not accepting that's a relevant test. We're saying that's what Justice of Appeal Clark found, that there was a lack of actual authority of Messrs Jones and Harter, owing to an undeclared interest in the HOA.
But in your paragraph 44, you do seem to accept that having reason to believe is...
We do that. And I'm not going to resolve from that. That's what we do accept. But what I say is reason to believe is there equated to actual knowledge, not simply being put on inquiry.
But sorry, reason to believe is clearly different from actual knowledge.
It is. But it is. But it's a... Well, it's very it's difficult to do, but what we say is reasonable. It's very different. It is where you have reason to believe, which is of the quality of actual knowledge. Essentially, it is actual knowledge. You may not actually have the knowledge, but you know everything there is to know, which, if you thought about it, will give you that actual knowledge. But put on inquiry is not enough. What criterion is in bundle 7. Criterion is in bundle 7. It's at tab 6. And this, picking it up at the head note at 2047, being that the claimant company and the first offending company formed a limited partnership, governed by an investment and shareholders agreement, fearing that the claimant might be taken over by another company. The managing director and another director of the claimant signed a poison pill agreement with the first defendant, amending the original agreement and giving the first defendant the right to have its interest in the partnership bought out on favourable terms in the event of another company gaining control of the claimant or of the chairman or the managing director ceasing to be involved in its management. The takeover did not occur. Subsequent negotiations to rescind the poison pill agreement broke down. The managing director was dismissed, and the first defendant served notice to exercise its option to be bought out. The claimant commenced proceedings to have the poison pill agreement set aside. On its application for summary judgment, the judge found that the claimant's entry into the agreement had constituted an improper use by its directors of their powers, and that the first defendant was not entitled to rely on the director's apparent authority to commit the claimant to the agreement. He accordingly awarded the claimant summary judgment and declared that the first defendant was not entitled to enforce the agreement. The Court of Appeal allows an appeal by the first defendant ordering that the matter should go to trial. On appeal by the claimant, held dismissing the appeal, that the critical issue was not, as the courts below had regarded it, whether it was unconscionable for the first defendant to hold the claimant to the agreement, but whether the claimant's directors had had actual or apparent authority to sign the agreement on its behalf. That on that issue, the question arose whether it was open to a board of directors of a public company to authorise the signing on its behalf of such an agreement, that question had been raised for the first time during the hearing of the appeal. The House was not in a position to resolve it on the available material. The matter therefore had to go back to trial. Go back for trial. And the issue on the application, Lord Nichols points out at page 1847 in paragraph 2, third line, the only relevant issue on this application is whether the second supplementary agreement was a valid and binding agreement. And then the main judgment was given by Lord Scott. And what he says, if I may take you to page 2050, I see Lord Justice Carnwath was in the Court of Appeal. One sees at 2050 at...
I only got it all wrong. So.
Lord Justice Carnwath looked at a different question, I think it's fair to say. It wasn't the one that appealed to the House, but it...
it comes back to me.
Oh, not to Horns, I hope. Anyway, it's at 2050. The issue is now before this House.
Sorry, where are you reading?
I'm reading at 2050. I'm reading 4 lines down, after Lord Justice Carnwath agreed and set aside the correction. Thank you. The issue is now before the House, remains as it was before Mr. Justice Hart, whether it is sufficiently clear on the facts at present in evidence that Oaktree cannot enforce the agreement against Criterion, or whether there is any other reason why the declaration sought by Criterion should not be made at this stage. So it was a summary judgment application. Lord Scott deals with the judgments in the courts below at page 2054. And what he says at 2057, having considered the approaches of the courts below, at 2057, paragraph 30, just above that paragraph, perhaps I can take it to paragraph 29. If Mr. Glazer and Mr. Palmer had no actual authority to sign the SSA, do they have apparent or a sensible authority to do so? The answer to this question depends on a number of considerations, as to which there is at present no clear evidence, and at least one of which raises an issue of considerable public importance. The issue I have in mind is whether it is open to a board of directors, public companies, to authorise the signing on the company's behalf poison pill agreements intended to deter outsiders from making offers to shareholders to purchase their shares. At the bottom of that paragraph, he says, 3 lines up, could it be said that they or any of them had apparent authority to conclude such an agreement? And then in paragraph 30, this case turns, in my opinion, on the authority issue. And he sets out, he says, if Mr. Glazer and Mr. Palmer either had actual authority to conclude the SSA given by a person or body with power to confer that authority, see British Bank of Middle East and Sun Life Assurance, and especially Per Lord Brandon, or if they did not have actual authority, had apparent authority to do so, then I can see no reason why the SSA should not be held enforceable against Criterion. If, on the other hand, Mr. Glazer and Mr. Palmer had neither actual nor apparent authority to conclude the SSA, then the SSA could not be held enforceable against Criterion. Mr. Glazer and Mr. Palmer might be liable to Oaktree for breach of warranty, but the SSA would not be Criterion's contract. The conscionability or unconscionability of Oaktree's behaviour in seeking to hold Criterion to the SSA would in either case be irrelevant. Both Mr. Justice Hart and the Court of Appeal thought that the SSA was clearly contrary to the commercial interests of Criterion. Mr. Justice Hart thought that Oaktree must have known, or to be taken to have known, that that was so. I do not wish to be taken to be saying that knowledge of this sort on the part of Oaktree, or knowledge by Oaktree, that Mr. Glazer and Mr. Palmer were in signing the SSA in breach of the duty they owed to Criterion, would be irrelevant to the authority issue. If a person dealing with an agent knows that the agent does not have actual authority to conclude the contract or transaction in question, the person cannot rely on apparent authority. Apparent authority can only be relied on by someone who does not know that the agent has no actual authority. And if a person dealing with an agent knows or has reason to believe that the contract or transaction is contrary to the commercial interests of the agent's principle, it's likely to be very difficult for the person to assert with any credibility that he believed the agent did have actual authority. So he's actually looking at gaining knowledge by what he knew to be the unusual nature of the transaction. It's not an application of Turkland. And then he says, in my opinion, the authority issue cannot be resolved by your lordships on this appeal. And to that extent, the House agreed with the Court of Appeal in sending it back to be determined. That's Criterion. Now, as you will have seen, that at paragraph 32 of their case, EACL, this is bundle 6, of course, at 1891. Paragraph 32 of their case, EACL says that they will, if necessary, submit the narrower Akai test, that the narrower Akai test is inconsistent with previous English authority, including 2 House of Lords decisions. And then the decisions that they rely on are then listed. EACL sorry, that's it. Of the 8 authorities which are listed, 6 of them were specifically considered by Lord Newburgh in Akai. and analysed them consistently with his findings in Akai. And the 6 which were considered by, of the authorities there listed by Mr. Howard, those which were considered in Akai were, as looking at paragraph 32 on bundle 6, page 1891, Underwood. Liggett was not referred to. It's a first instance decision, I think, of Mr. Justice Wright. Houghton was referred to. Morrison Canson was referred to. Rolled Steel Products was referred to. Armagas was referred to. In Akai, I didn't take you to that reference. It's paragraphs 67 and 68 of Akai. And Criterion Properties was referred to in Akai at paragraph 147. So 6 of the 8 authorities listed by my friend were actually considered by the Court of Final Appeal in Hong Kong, including House of Lords decisions, being Criterion and being Morrison Canson, and the other one, Armagas and Mondegas. Then the 2 authorities which Mr. Howard relies on as showing inconsistency are Liggett and Barclays Bank and Wrexham AFC. The effect of EACL's case on this is that, in effect, what they're saying is that Lord Neuberger, with the benefit of submissions of very senior counsel indeed, Lord Neuberger addressed those 6 authorities, but reached a decision which was inconsistent with each of them. Yet Lord Neuberger didn't state the inconsistency, or that he was finding differently from what those authorities stood for. And that, we suggest, is self-evidently improbable. But what we say in any event, and importantly, is Akai is not inconsistent with those 8 decisions.
But is it? I mean, I see there's academic criticism referred to as well.
There is.
Contrary to principle and misunderstanding of prior authority.
Yes, some misunderstanding, but Akai has been followed in Quinn in the Court of Appeal in this jurisdiction. Looking at the decisions upon which Mr. Howard relies, the Underwood case is in bundle 7 at tab 15 at 2231.
I mean, my dealing simply with this question is whether it's enough to be put on inquiry.
Yes, whether the test, it's a very, very narrow point indeed. Whether it's actual knowledge of the want of authority or something less, whether you need to show actual knowledge. It's the way that Mr. Sumption put it. Do you recall, I think, at paragraph 49 in Akai?
So it's actual knowledge or irrational not to
Your Lordship,
understand.
My Lord's absolutely right on that. So that's the question, whether Mr. Sumption was right or whether Mr. Cosmin was right. Mr. Howard would say that Mr. Cosmin was right.
As I understand Lord Neuberger's approach, he's drawn a distinction between issues relating to ostensible authority, where turning a blind eye is sufficient, what he calls blind eye knowledge, and questions relating to the rule in Turquin's case,
Yes.
where putting on inquiry is sufficient. And it's obviously, I mean, he himself says it's a narrow distinction between blind eye knowledge and being put on inquiry. But he's distinguishing, I think, some of the Morrison, Canson, and Rolled Steel as being cases which are really about Turquin's case, in the indoor management rule. And he only takes issue with one dictum of Lord Justice Slade in Rolled Steel, where the language of ostensible authority is used.
Yes. That's right. Your Lordship's absolutely right. And what he says in Rolsteel, there's only one sentence in Rolsteel which supports the notion which Mr. Howard is putting forward. But A.L. Underwood, we have always accepted that the nature of the transaction, I've accepted here, the nature of the transaction may be such as to undermine a parental authority. And you've seen that from Freeman and Lockyer. It's readily accepted in Freeman and Lockyer. And I took my Lords and my Lady through those. I'm not going to go through those again. But Underwood, the facts are summarised. Perhaps I can pick it up. I invite you in due course to look at the head note at page page 2231. I think, Lord, my notes, my 225.
Where do you find it?
I'm going to invite my Lords to page 2251 of the bundle 7, which is tab 15, 2251. It's Lord Justice Atkin summarises the facts. He says there, 4 lines into his judgment, an official of a limited company has fraudulently taken cheques belonging to the company, which he had authority to endorse, paid them into his own bank account and converted the proceeds. The cheques were drawn in favour of the company. Some were not crossed, some were crossed and some marked not negotiable. The bank are sued by the company for the conversion of the cheques and, in my opinion, are liable. The question seems to turn upon whether A.L. Underwood, the official in question, the sole director of the company, had authority, actual or ostensible, to deal with the company, with the cheques as he did. That's the issue. But it's quite clear it was a transaction of a highly unusual nature. A person taking cheques made out to the company and then paying them into his own personal bank account. I should just perhaps note this, is just at page 2238 going back, Mr. Upjohn raised 2 points on authority. And that's in the 4th line of the page 2238. So Mr. Upjohn's submission, but that article, Article 71, that article gives no authority to a sole director to pay the company's cheques into his private account. It only authorises him to conduct the business of the company and for that purpose to do what is necessary. But it is not necessary for the conduct of the company's business that he should pay its cheques into his own account. And the second, and then he says towards the bottom of the page, the last between 2/3 and 3/4 of the way down, he says this: secondly, even if Underwood had the authority of the company to pay in the cheques as he did, in so paying them in, he did not in fact act under that authority. He did not hold himself out to the bank as being the agent of the company, but as being the company that is to say, as principal, who owned all the shares. And so he wasn't even purporting to act as agent. And you'll see this, picking it up at Lord Justice Atkin at page 2252. About 6-7 lines down, he says, under ordinary, starting towards the end of the line, under ordinary circumstances, actual authority appears to be clearly negative. Nevertheless, it's contended that the fact that Underwood was the sole director and practically the sole shareholder gave him, in pursuance of the article's actual authority, he was entrusted with all the powers of the company. The company can only act through its directors, and the directors, or director if only one, could do what they willed with the company's assets. If this means anything, it means that a board of directors acting as such have actual authority to defraud the company by using the company's assets to pay debts due to butchers or moneylenders by the individual directors. Such an act is quite outside the class of acts. So it's the usual authority notion that comes in even here. Such an act is quite outside the class of acts, management of the company's business, authorised to be done by the board. And then he goes on to say, if then there was no actual authority, the question remains whether Underwood was acting within the scope of his apparent authority in such circumstances that the company would be precluded from setting up lack of actual authority. I think he was not. He then deals with cross-examination, and he says at the bottom of page 797, 1, 2, 3, 4, 5 lines up, after the answer yes, these admissions, fortified by the whole facts of the case, appear to demonstrate that in disposing of the cheques as he did, Underwood was not acting within the ordinary scope of his authority, but was doing something unusual, which ought to have attracted the attention of the bank servant. It was said if inquiries had been made, Underwood could easily have made lying explanation, which would have set at rest any doubts. I agree with the judge that even if well-founded, that would be an insufficient answer. I think it more than doubtful whether Underwood could have given a satisfactory answer to the obvious question. Has not the company a banking account? And if so, why are not these cheques paid into that account? Even if the first transaction so investigated went through, it is unlikely a similar disposition of the cheques would have been repeated. It is further to be noticed that the bank cannot rely upon any apparent authority of Underwood to deal with the cheques on behalf of the company, for he neither purported to do so, nor did the bank ever suppose that they were dealing with the company. The transaction on both sides was treated, as in fact it was, as a dealing for Underwood's private account. So what we say in relation to that case, it was a case involving a highly unusual transaction, and the agent had not even been purporting to act as agent. And therefore, it is not a case which is in any way inconsistent with Akai. And we've seen what has been said in Akai about that case. The next case I'm going to come on to, I was going to start at 4 minutes past 1, but I think you may suggest it's a convenient time to adjourn.
I think I might very well suggest that, Mr. Todd. Thank you. The court will adjourn.